In your opinion, why do black lawyers matter?
Black lawyers can matter. They won't unless they make a conscious effort to matter. Just being black and showing up is not enough.
I first met Zach when he became a magistrate judge in the Eastern District of New York during my days as an AUSA there.
I met Zach, I believe, as a fellow member of a committee of the City Bar, the Criminal Law Committee, in about 1980.
And even though I was committed as U.S. Attorney to serving everyone in the district, in the Eastern District of New York, regardless of color, race, religion, national origin, I would have considered myself a failure if after I'd left the U.S. Attorney's office, you couldn't tell that a black man had held that job.
The lesson in Zach's career is that you can keep your moral compass no matter where you are sitting. And in fact, that's what you bring to every job.
If I were to find one word to describe Mr. Carter, I think it would have to be fair. Fair to all people, fair to all points of view.
And I think that young attorneys need to learn, particularly in litigation practice, that there's joy you can take in the preparation itself. I mean, it doesn't have to be a drudgery. Knowing that you're going to walk into court better prepared than your adversary, it is real stress reducing.
He liked to build consensus. He liked to discuss with people of different points of view. He liked to discuss until people agreed.
You know, Zach is actually an accomplished musician in his own right. He plays piano and plays organ. But if I had to pick one song that I would think of when I think of Zach, Earth, Wind, and Fire, Keep Your Head to the Sky.
But frankly, the most fascinating person, the most influential figure in the overall that I'd want to sit and have dinner with would be Malcolm X. And Malcolm X was a really astute observer of American life and understanding of history and how the forces had come together to oppress a people, the impact they had both on the oppressed and the oppressor.
Zach, congratulations on being awarded the Metropolitan Black Bar Association's Public Servant of the Year Award. No one is more deserving. Congratulations, my friend.
Congratulations, Zach, on being awarded the MBBA's 2020 Public Servant of the Year Award.
Okay, great. Well, there you go. And then everybody must be joining us. So welcome, everybody. Thank you for joining us for the Metropolitan Black Bar Association's 30 Days of MBBA Fireside Chat with our 2020 Public Servant of the Year, Zachary Carter. Mr. Carter, thank you so much for joining us today.
Oh, my pleasure.
Yeah, so I have to say, I'm a pretty big fan, and I'm very excited that we're here today, and I get to do at least this fireside chat with Zach. I remember one of the first things I did once my term began as president of the Metropolitan Black Bar Association is see if I could be able to set a meeting and speak with Mr. Carter, and he was gracious enough to make time in his schedule so that we could kind of talk about, you know, what it is we could do with an organization like the MBBA to make sure that we're advocating on behalf of folks who in communities that we came from, as well as do what we can to make sure that we have a robust and diverse legal profession. So for those of you who are less familiar with Mr. Carter, Zachary Carter served as Corporation Counsel of New York City under Mayor Bill de Blasio. During his tenure, Mr. Carter resolved longstanding litigation, ushering in a new era of equity and justice for the city of New York. Memorable settlements range from the overuse of stop and frisk and the Central Park 5 case to excessive uses of force at Rikers Island and the underrepresentation of racial minorities in the ranks of FDNY, all in terms that reconcile the values of fairness and equity with the obligation to keep New York safe. As corporation counsel, he oversaw a staff of nearly 1,000 attorneys, approximately 700 support professionals, and defended the city, its agencies, and the employees of the City of New York's Corporation Counsel in litigation. Prior to becoming corporation counsel, he served as United States Attorney for the Eastern District of New York under then President Bill Clinton. His term as U.S. Attorney was notable for the prosecutions of police officers in the Abner Louima case, Jordan Belfort, and those involved in the death of Yanko Rosenbaum during the Crown Heights riots of 1991. Between his tenures in government service, Mr. Carter served as a partner at the law firm Dorsey & Whitney. He is a graduate of Cornell University, where he participated in the 1969 takeover of Willard Straight Hall. And he was admitted to the New York bar and eventually became also a New York City criminal court judge. So what we need to do is make sure we can get you, I guess, to do some teaching, become an in-house counsel, and you've done everything there, from being a federal judge to a criminal court judge to a U.S. attorney to corporation counsel. So I guess with that said, welcome again, and it's great to be here with you, Mr. Carter.
Good to be here.
So I think for today, I mean, there's so many issues and so many topics that, we could be able to get into. But I think maybe what we should do is just get started with, where you left off, right? So can you tell us a little bit about your decision to become corporation counsel, and what are some of the achievements that you're most proud of?
Sure. The opportunity to become corporation counsel really came out of the blue. I had left the U.S. Attorney's Office in 1999, July of 1999, and joined a law firm, Dorsey & Whitney, that was headquartered in Minneapolis and had a sizable office in New York. And I'd been with that firm for 14 years and expected to retire from the firm because, quite frankly, I loved the job of U.S. Attorney. It was an opportunity to make an impact on matters that particularly concern the communities of color, but also serving all of the residents of the Eastern District of New York, Brooklyn, Queens, Long Island, Staten Island. And I never thought I would get a second act in public service that would be present the same level of challenge and the same opportunity to contribute. But the Corporation Counsel's Office, and I'd done work in connection with the Corporation Counsel's Office for, off and on for years, presented that opportunity. And in some respects, an even broader opportunity. When you are the U.S. Attorney, you are appointed by the President of the United States, but the person directly responsible for your elevation is the senator from your state who recommends you to the president. I've met Bill Clinton maybe once or twice in ceremonial matters, but I doubt that he'd know me if he tripped on me. The person who was really responsible for getting familiar with my qualifications for the job was the late Senator Daniel Patrick Moynihan. And so after going through his merit selection process, I was nominated, and the president accepted the nomination, and he sent me to the Senate for confirmation. I was confirmed. The reason why the Corporation Counsel's Office appealed to me was because even more so than the U.S. Attorney's position, I could affect the lives of the citizens of New York in the broadest possible ways. The city of New York, it's not for nothing that the title of the job is Corporation Counsel. And the city is a multivaried, multinational corporation. And every legal problem that confronts a multinational corporation confronts the city. Because we think about, sanitation, we think about the police department and the fire department. We think about emergency services and health. But there are an extraordinary number of contracts, for instance, that are consequential to the operation of the city that the Corporation Council is responsible for drafting and negotiating. Environmental issues. Our affirmative litigation division deals with issues that are incredibly varied in terms of city regulations, and particularly First Amendment issues involving the right of free expression. So you may remember that summer a few years ago that we at the Corporation Council like to think of as the summer of jiggle and fuzz. And that's when the big furry cartoon characters in Times Square were basically harassing tourists and shaking them down for contributions, whether they wanted to contribute or not, in exchange for photographs and the like. We had to try to come up with a creative solution to permit those characters to perform, because they were performance artists and their performances are protected in public by the First Amendment, to try to find a space for them to perform that respected their First Amendment rights without trampling on the rights of tourists not to be harassed. And so that was the kind of thing the affirmative litigation department got involved in. But let me stop there, because I could go forever, because the mission of the Corporation Council office is so broad.
Yeah. Well, no, I mean, well, this is your day. This is your fireside. So you can go as long as you like. And, it's actually interesting as you're mentioning some of that, because one of our the MBBA board members served for several years with Corporation Council. And one of the things that I remember always saying is how, a lot of the complex legal analysis and the cases and the sophistication of some of the cases that she had to work on helped her develop, certainly with her writing, but also the opportunity to be able to argue some of these cases, in court. And, sometimes we think of public service and we only think of it from one vantage point, which is, giving back and making sure that you're protecting the community. But the other thing is, just as attorneys who are developing in your own right, is such an amazing opportunity to be able to develop your skills that you can become, the type of legal advocate that you may want to be. So as you mentioned with the Corporation Council, one of the things that I was always so great to see that, I think it was within, maybe even a month, after you assumed the role, very quickly you were able to settle the Central Park 5, or now the Exonerated 5, case. And can you tell us a little bit about what it went into that decision and why you thought it was so important to be able to resolve that matter?
Sure. Well, first of all, the mayor, when he was a candidate for mayor, had made a pledge to resolve that case. And the mayor's not a lawyer. The case had not been investigated by his campaign, but there had been a documentary film that had purported to review all of the relevant issues in the case, and on the basis of that, and there was no reason to doubt the essential finding of that film. The mayor had made that pledge, but he made a pledge to me in my capacity as Corporation Counsel that I would have the opportunity to review it as a lawyer and to make a judgment about whether or not the evidence supported the resolution that he had indicated that he would like to reach. And when I came to the Corporation Counsel's office, I encountered a group of extraordinarily accomplished, hardworking, dedicated attorneys who had been defending the city for several years in fierce defense of its position that that the case should not be resolved because there was a belief that the evidence did not establish that there had been a constitutional violation. So I made a pledge to the lawyers in my office who had been so invested in that case that I would not even view the documentary film, because I had not viewed the film, that I would not view the film until I had read every document, reviewed every transcript, viewed every videotape of statements of witnesses, and come to my own independent conclusion. And I kept that pledge. I was there, notwithstanding the fact that I had to run an enormous office. I was there nights and weekends, going through thousands of pages of documents and personally viewing the interviews of the 5 young men by the detectives and the assistant DA on the evening of the occurrence, but also reviewing the trial transcripts and the like. And ultimately, I came to the conclusion that with respect to the allegations of rape, that is the savage attack on the Central Park jogger, that the better part of the evidence established that they were not guilty in any complicity in the assault on the jogger, Miss Mealy. And I emphasized that my conclusion was confined to the most serious charge, and that is the rape of Miss Mealy, which frankly drove the harsh sentences for all of the other offenses for which they were convicted. Because while the evidence established that they had not committed that rape, and that the rape had clearly been committed by another individual whose DNA was found on her person and in her vaginal cavity, that no DEA associated with any of those 5 young men was found on her, and having reviewed the videotape confessions, so-called confessions of the kids, that with respect to the rape, that the statements were inconsistent. They were not logically consistent when they were viewed individually. Frankly, in my view, these were not only teenagers, but many of them very young teenagers. Not only did they not, based on my experience, describe credibly a rape, frankly, they sounded like, teenage kids who had not actually experienced a sexual encounter personally and were flat either making it up or accepting the suggestions of the detectives who were interviewing them. And it's in the research on these circumstances, particularly with young people, or in one case with young people who have mental capacity issues, they are eminently suggestible, even when a detective is operating in good faith, because they have come to a firm conclusion about what they believe the truth to be, and it tends to infect their questioning. On the other hand, the consistency that you would like to see in establishing a commission of other offenses was there with the other allegations with respect to these young men. That is, that they entered the park as part of a much larger group, and that other assaults on several other persons in the park that night
they had in fact participated in. That did not undermine in any way the fact that they had been the victims of a miscarriage of justice. Because if they had only participated in those other attacks, that while they were serious, not nearly as grave and as serious as the attack on the jogger, the rape and vicious beating of the jogger, it is highly unlikely that they would have served the kinds of sentences that were imposed because of the belief that they had participated in this vicious assault on the jogger. And so my determination that the case should be settled was settled on the basis of the evidence that established that, in my view, very strongly, that they had not participated in the rape. But it also reflected my view that their conviction, based on the conventional wisdom within law enforcement at the time, at a time long before the existence of the exonerations based on the Innocence Project work, long before it became not just speculation, but well known that innocent people confess. That based on the conventional wisdom of how to approach interrogation at the time, both on the part of attorneys and assistant prosecutors involved in the process, it was my conclusion that while this was a tragic outcome, it was not as a result of intentional wrongdoing on the part of the police or the prosecutors, but there were mistakes. There were indications that the stories just did not hold up, that were missed because of a strong presumption that's frankly embedded, and everybody on this call, I expect are lawyers, a strong presumption in our jurisprudence that no one confesses except guilty people. And now people would say, well, what is that based on? Well, let's think about it. We all took evidence, right? What is the number one exception to the hearsay rule? An admission against penal interest, a confession. It is so strongly embedded in our psyche as humans, in our jurisprudence as lawyers, that only guilty people confess. It's baked into the rules of evidence. And that's what non-lawyer cops have to overcome when they've come to the conclusion, when they hear someone say the magic words, make an inculpatory statement, and are disinclined to doubt that statement because it fits into their preconceived notion of what happened. And so you might ask yourself, well, why wasn't I a victim of that? Well, first of all, I had the benefit of, by the time I was examining the case, 20 years later, of all the work that the Innocence Project had done, over 200 exonerations, many of them based on false confessions. So I didn't have to speculate about whether or not innocent people confess. That was an established fact. The other thing I had the advantage of in terms of 2020 hindsight was to be able to do a review and to come up with some at least one hypothetical myself that gave an explanation as for why the officers came to the conclusion that these kids were involved, and that the person who actually had whose DNA was found was by some elaborate theory also involved with those kids. I came to the conclusion that he acted independently because I had the opportunity to look at it in hindsight. And one hypothetical I posed to myself was, this is an incident that occurred in the northwest quadrant of the park. Suppose Miss Maley's nearly lifeless body had been found in the southeast quadrant of the park. All the other assaults, all the other activity of this group of some 30-odd youngsters and assaulting people in the park occurred in the northwest portion of the park. And because she was found in that area, it was assumed that the same group of kids was involved in her assault. If her body had been found in the southeast quadrant of the park, the police never would have suspected those kids. Yeah. And they would have done what good cops do. They would have asked, when's the last time somebody was raped in the park? As it turns out, just 2 days earlier. They would have asked for the rape kit. They would have immediately found that there was a hit between the suspect in that rape and the DNA specimen recovered from Miss Mealy, and he would have been the one and only suspect. It was difficult for them to accept the coincidence when it was in the same geographical area, but that defied logic. And again, their minds were closed to the possibility that there was an alternative explanation because of the power of the belief that, again, is embedded in our jurisprudence that only guilty people confess. So that was how we came to what I think was a just conclusion and resolution of that case.
Right. Yeah, and that makes a lot of sense. I mean, clearly, not all of us were privy to the same type of evidence that you and your attorneys were able to see. But for example, I did get to see the documentary that was done on the Central Park Five. And the one thing that I even remember today is just how scared the kids looked while they were there. Or it seemed like they got to a point where they were just saying, like, what is it you want me to say? I just want to go home. I don't want to be here. You get to a point where you're just like, almost, you're just trying to figure out, what you can do so this can be over. And, it's certainly been a few years since I've seen it, but I do remember there being almost like certain suggestions that, if they heard if they said what they were looking for, that this all could be over. And I think that when you think about the Innocence Project, you think about some of these other instances where you find exculpatory evidence later on or DNA evidence that shows that, some of these convictions were incorrect. That's a part of the process sometimes. And one of the things that I just thought was very interesting is that I believe the settlement was somewhere around $41 million. And I remember there being an article from the New York Times indicating when they did the math that it seemed like each of the individuals, each member of the exonerated five, received $1 million for every year that they were incarcerated. At least that's the way it kind of broke down to. So, just it says how important it is that, we have thoughtful people who are in these roles so we could be able to make sure that justice is meted out correctly. And the last thing I guess I would say about that too, is that, even though, maybe, there was kind of a mandate to at least review this when you got started. I mean, the civil lawsuit was brought, 11 years ahead of time beforehand. So it's certainly, at least to me, and you may not be able to say this or what have you from your vantage point, but to me, folks could have been able to work on that case a long time before. And for whatever reason, it seems from someone on the outside that it wasn't a priority until you and your administration came in and to be able to get it done. So,
well, in fairness, the Corporation Counsel's office is like the giant civil division of a U.S. Attorney's office. All right, and their bread and butter are, in terms of the largest part of the caseload, are tort actions brought against the city. All right. The closest thing to a criminal practice that the Corporation Counsel's office has is the Family Court Division, in which we prosecute, or the presenting agency, against young people who are accused of offenses that, if they were adults, would be considered crimes. All right. But there's no overlap between the attorneys who specialize in the family court practice and those who are evaluating a case like the Central Park jogger case. So I brought to that case the only expertise in criminal justice matters that had ever been visited on that case. And that was just serendipitous. It was just the right person being there at the right time, because I had investigated. I've been investigating criminal cases, both state and federal, since 1975. So I had all of that experience that I was able to bring to bear.
Right, definitely. Great. So, but actually, this is probably a nice transition as well, because I mean, during your term, one of the other notable times, I guess, as U.S. Attorney, was your prosecution of the officers in relation to the Abner Louima case. And, when we start to see some of these, high-profile police brutality cases we've seen, whether we're talking about George Floyd or Breonna Taylor or Eric Garner or what have you, I guess what I'd like to know is, how do you think things have changed, and what can we learn from, I guess, your term, handling some of these cases, and what needs to be done to try to reduce, or frankly, try to do everything we can to make sure that instances like this don't happen in the future.
Well, frankly, things have not changed enough. All right. I mean, I am very proud, and I think all of us on the team that were involved in prosecuting the officers who assaulted, who anally sodomized with a broken broomstick, Abner Louima in that precinct house that evening. We were all proud of that prosecution. All right, and we had the cooperation of NYPD, the investigative work, the conscientious work of the FBI, because it was a case of singular depravity, and not even the PBA was aligned against us in bringing to justice people who would commit that vile act. All right. That's frankly a bit of an exception to the rule. And part of it is because of the nature of police work that we will always be challenged to address. And it is separate and overlapping with the racial issue. So let me start with those things that I regard a part of police work that create an obstacle to bringing justice to victims when police abuse their authority. I guess there are a few things, factors. One, not everybody who pursues a job as a police officer is the kind of person you'd want to be a police officer. There are good reasons to become a police officer, and there are bad reasons to become a police officer. The good reasons are people who really are people who want to endanger their own safety to bring public safety to the masses, and to do it within the rules. They don't want to abuse anybody. They just want to get the bad guys off the street. All right. And in my experience, that is the substantial majority of the police officers. But think about the kind of people who are going to be attracted to a job that gives you a gun and a badge and the authority to boss people around. They're not always going to be the ones you want on the force. And no matter how sophisticated your psychological screens, you're not going to exclude all of them, particularly in a force the size of the New York City Police Department. So there has to be constant vigilance, training, orientation, surveillance, to make sure these officers are exercising their authority in an appropriate way. Then there's the issue of what I regard as excessive empathy in certain categories of cases. Now, what I've found in my experience is that when there is a questionable shooting, you're not going to find many police officers who think that a bad shooting is a good thing. All right. So to some extent, and what I've always found in having investigated lots of shooting cases and lots of non-lethal force cases where people have been brutalized with fists or clubs, right? That in some respects, I find the non-lethal use of force cases to be the more serious, because shootings are most often, in my experience, a fear response. Sometimes it's an unjustifiable fear. Sometimes they see that black or brown face and they feel fear in situations where they shouldn't. They're suspicious of a so-called furtive move when they shouldn't be. They think that something may be a gun when it's a beeper or a cell phone or a wallet, because in that heightened sense of fear, right, that is exacerbated by racial stereotype, you know, they are inclined to fire faster than they would, but out of fear, not out of anger. So I find shootings are generally a fear response. Beatings are very often an anger response, which is why in the Department of Justice Civil Rights Division, they are actually characterized, the beating cases, as summary punishment cases, street justice cases, right? Because of an understanding of the difference of psychology in the beating and choking cases than in the firearms cases. So in terms of being able to penetrate what has been called euphemistically the blue wall of silence, you're going to get more empathy in the beating cases, where many officers, unfortunately, and I think it's misguided, take the position, there before the grace of God go I, where unfortunately, even some supervisors and people who are in charge of making judgments about whether or not a police officer's acted inappropriate or not will sometimes look at cases with excessive empathy, right? And bend over backwards in situations where the evidence should compel a reasonable investigator that something inappropriate happened here. There's a tendency to resolve all doubts in a way that I think is over the top and excessive in favor of officers. And this is just not the NYPD. This is inherent in police work around the country. There actually is a less of an inclination to ignore compelling evidence of a bad shooting than there is when there comes to be a non-lethal use of force. And while all bad shootings have the worst possible outcome, many have the worst possible outcome, and that is the death of a human being, there are actually fewer of those proportionally than there are the uses of force that are non-lethal, though very often non-lethal uses of force, that is a use of force without a firearm, can also result in various serious injury and sometimes death.
Yeah. Okay. So, with all of this, this obviously being a topic that, we've been discussing for several years. I mean, certainly, I know one of the reasons I became an attorney was after the Amadou Diallo case back in 1999. Some of those folks who may be more recent members, it may be something like the Eric Garner case, I guess 6 years ago. All of these cases that, we continue to be seeing this. And what I think has also been an issue is a lot of folks feel like there had been some type of violation of someone's rights, but, the officers don't always necessarily seem to be held accountable for that. And I started to bring across this whole issue, and there's people starting to questioning the breadth of this concept of qualified immunity. So do you have any thoughts on whether or not qualified immunity as is where it needs to be? Or is there another way that we may be able to, that the courts maybe need to tailor it more so that it, can hold bad officers accountable while also protecting some of the more, officers who are acting in good faith?
I think judges should not apply qualified immunity reflexively. It has to and can be applied in a way that is consistent with common sense and equities and the available evidence. The purpose of qualified immunity is to hold harmless an officer who had to make an impossibly difficult decision instantaneously. And the decision, while in hindsight you could say turned out poorly, was not one that you considered to be outrageous, to be unconscionable at the time the decision was made. All right. And in my experience, in most cases where someone has engaged in outrageous conduct, with something that borders on an intentional constitutional violation, the qualified immunity shouldn't apply in the first place. I think that a judge who's written extensively about that, even though it may come out slightly differently about what the remedy is Jack Weinstein in the U.S. on the federal bench in the Eastern District of New York. He believes that the application has broadened and broadened and broadened to the extent that it's hard to imagine any conduct that wouldn't fit qualified immunity. But that's as a result of case interpretation. That's as a result of determinations that have been made by judges. Now, it may be that there has to be legislation that commands judges to apply the defense of qualified immunity substantially more narrowly than they have. But I believe judges have within their discretion to apply it in a reasonable and a narrower fashion than they do now.
Mm-hmm. Yeah, great. Yeah, that makes a lot of sense. We're flying through our time. We only have like another 15 minutes. So
I'm glad when you're having a good time.
Exactly. Such a, sit here, by our fire, maybe have a little hot cocoa and have a nice conversation. And
we don't have to restrict ourselves to hot cocoa.
There we go. But I guess another topic that, I think is worth trying to delve into has to do with our federal courts, right? In addition to serving as a corporate counsel, a U.S. attorney, you also served as a magistrate judge for a while as well. And one of the things that I tend to hear a lot of, and we're probably all having some of these same conversations, is that when we look at our federal courts, whether we're looking at the Supreme Court, where it seems like it's been so polarized, where, the folks who end up being, just even being considered, a lot of it is based on ideological issues as opposed to their legal judgment or legal analysis skills. But just generally, all the federal judges that are out there, what can we do to make sure that we could preserve the impartiality and the unbiased nature of the individuals who are appointed to these courts? Because it's difficult, I think, sometimes for people to feel like a decision was made is a decision that was made on the law, when folks feel like someone is, more and more tends to be appointed just because of political stances. What can we do to make sure that, we can preserve the sanctity of our courts?
I think part of it has to do with judicial selection process, both before Senate confirmation gets involved and afterwards. All right. I was involved in judicial selection for many years. I was the chairman of Mike Bloomberg's Judicial Selection Committee for all 12 years of his mayoralty. And I was involved as corporation counsel in the judicial selection process in that capacity. So I was involved for almost 20 years in that. And what I've always said about judges at every level is that judges have to have equal components of head and heart. A judge who is all head and no heart will seldom be fair. On the other hand, a judge who's all heart and no head will seldom be right. All right. So you have to have both. Where I think, and it's been incredibly frustrating to be an observer of the federal judicial selection process when the Senate gets involved, and being a lifelong Democrat, I get frustrated to the point of wanting to tear out what's left of my hair when Democrats let themselves be narrowed into a discussion about whether a person has legal technical qualifications or not. Did they go to the right school? Did they have the right federal clerkship, right? Or multiple clerkships, right? Were they on law review, okay? You know, during the course of their practice, were they regarded as sound technical practitioners? There are times when, as soon as the person is proffered and their academic record seems stellar, Democrats are ready to throw in the towel. But here's what we as lawyers have to focus on in terms of evaluating the whole person who's about to become a federal judge for life, making consequential decisions that affect real human beings. All right? It is important to know what's in a person's heart as what's in their head. Think about the most important skill we learned, particularly as litigators, when we were in law school. That's to be able to argue with equal force either side of a debatable proposition, right? Now, we get pretty good at that by the time we finish law school. You get even better at it when you've been practicing law for a while. By the time you're in that small cadre of people who are reasonably qualified to be district court or court of appeals, or God forbid, Supreme Court judges, you should be one of the best in the country at being able to articulate a argument in support of either side of a closely contested case. So how can we predict how a judge is going to come out? It's not based on what's in their head, because we know they're smart enough to come out on either side of the issue. It's what's in their heart. What do you believe about a woman's right to choose? And don't dare refuse to answer my question. You know, what do you believe, right, about the Second Amendment, right? What do you believe about our democratic, our democracy values in terms of our right to vote? What do you believe about a history of voter suppression? And can you honestly tell me that you believe that's all over? That was in the past. That was during Reconstruction, and it's not persisted until the present day. And I think that senators have to be persistent in asking those questions about people's core beliefs, because expressing your belief about a subject does not require you to say how you will rule on that subject as a judge. It just helps the person making a decision about how to exercise their advice and consent function, whether or not they think you, notwithstanding your technical qualifications, are an appropriate candidate at this time for this particular spot on the Supreme Court or the Second Circuit or the district court bench.
Okay, great. Well, hopefully some folks out here, maybe some of those senators are listening today.
Oh. Write your senator right now.
Right. So, one of the other issues, I think is especially of importance here with the Metropolitan Black Bar Association has to do with diversity on the bench. And it's hard just to ignore the fact that just over these last 4 years during this current presidential election or presidential administration, of the 50 Court of Appeals judges that were appointed over this time, none of them were Black. And it's hard for me to just say that, well, it's just because there aren't enough qualified candidates. I've, in this role, as well as others, I've seen a number of folks who certainly could be able to do that type of work. What is it we can do to make sure that we have a pipeline, or that, you know, people of color are being legitimately looked at for positions to join the federal branch, as well as positions to be able to succeed, you know, in that profession?
Well, the practical reality is the appointment of federal judges is part of a political process. A senator of the president's party in a particular state has the right to, by tradition, to recommend a federal judge to the president, and then the president gets to nominate, and then the Senate comes back and makes a judgment as to whether or not they should be confirmed. And voters have to organize and hold senators accountable for consistent votes that do not take fair diversity into account. I mean, to have a federal judiciary that has not walked a mile in the shoes of substantial portions of America's population is just not fair in reality or in appearance. But the only way that's going to change is if senators feel that there will be consequences and at the polls for failing, particularly as miserably as going 50-0 in appointing. And frankly insulting to African American and Latino lawyers and other lawyers of color to say that you could not find a single, you know, qualified African American judge for any of the courts of appeals throughout the United States. I mean, it's I don't know how much time we have left, but if we're near closing, it just sometimes we have to make arguments that are grounded as much in common sense as in law. So one of the cases I inherited to resolve when I was corporation counsel was the long-standing lawsuit, discrimination suit against the New York City Fire Department, because they had a percentage of African-American firefighters in the low single digits. And one of the arguments I made, you know, to even within my office, to people who had been working on this case for years and defending what I had viewed was the indefensible, and frankly, an argument that I'd made to, you know, to my predecessor and to, you know, and to the mayor, you know, when in terms of informal conversations about this, and when I was chair of the mayor's committee on the judiciary, was let's think about what it takes to be a first-rate firefighter. You have to be physically strong, right? You have to be reasonably athletic. You've got to be smart enough to process complicated instructions on the fly, because one day it may be a simple house fire, the next day it may be the World Trade Tower.
Right.
You've got to have the kind of physical courage in which you're willing to risk serious physical injury or death. And you have to be a team-oriented individual. Haven't I just described an NFL football player? Yeah. Have you noticed any shortage of blacks in the NFL?
Yeah.
All right. Or for that matter, in the armed forces, where you have similar attributes of skill and character and personality. So you can't claim you can't find these people. They're out there. And the same could be, you know, said of judges. You know, if you can't find a Republican, then you can certainly find based on doing a careful, a nationwide search, a sufficiently conservative, ideologically conservative Democrat or independent to fill those slots. You can't say that, in this situation, oh, we couldn't find a Black Republican judge. That's nonsense. They probably exist, a Republican, fully capable African-American Republican lawyers who would be qualified for elevation to the courts of appeals. But you certainly could find some independent or someone who was largely, based on their long career, apolitical, and based on their performance as district court judges, that established that they are people who just call them like they see them without in ideological bias one way or the other.
Right. Yeah. And, the truth of the matter is, I feel like we see them every day. Every day, I have you have a court case in federal court. There are a ton of attorneys there, of color who have a mastery of the law. Likewise, there are also a number of state court judges who have done very well for themselves or very well respected, who I'm sure would also make terrific candidates out there. So,
absolutely.
It's just one of those things that's frustrating, but the work isn't done, and there's just more to do. So, last thing we want to go into was issues maybe regarding voting, given that I believe I heard that there's a important election that's coming up, but we're already at an hour.
Rumor has it.
What's that?
Rumor has it, yeah.
Right, rumor has it. Yeah, but we're already at 1:29, so I want to be mindful of the time, especially for those who tuned in for us. But I'd just like to say, thank you again for taking the time to speak with us. Everyone I know who've probably heard at this point that, I've always looked at you as certainly as one of my heroes in the profession. Just think about all the folks that you've been able to, the lives that you've been able to affect, folks such as Loretta Lynn, such as, my boss, one of my bosses, Barbara Underwood at the New York State Attorney General's office. And even though COVID made it a little difficult for us to be able to have the gala that we would have liked this year, we're certainly proud of the fact to have you as our public servant of the year. And just very thankful on a Saturday morning, able to spend a little time with us to talk about some of these social justice issues and just, figure out what it is we need to do to make a difference in our world. So thank you very much for your time. And I don't know if you have any last thoughts. What's that?
It's a pleasure to have the conversation.
Great. And I'm sure we'll probably have more in the future. So take care. And to everyone who joined in for us, this is just one. So keep on keeping in mind that there will be other events during these 30 days of MBBA. And thank you for tuning in. And, just as Metropolitan Black Bar Association says, as MLK also said, is that injustice anywhere is a threat to justice everywhere. So make sure you're going out there and protecting all of us. Have a good day. See you guys.
See ya.
So.